evening and welcome to the May 15th, 2023 meeting of the combined work session and public hearing of the Village of Southampton Planning Board. Can I get a motion to open the meeting, please?
I'll move to open the meeting.
Okay, all in favor?
Second.
All righty, let's start. From what I understand, we have a lot of adjournments in our work session, so why don't we run through those fast and then we can get to the one item for business tonight. Oh, actually, let's do the item for business and we can just run through adjournments later.
Okay.
That'll save your time, sorry about that. So on the application for 554 Hill Street, the public hearing was held open through this meeting with a May 1st deadline for document submissions. And as far as I know, everything is here and has been reviewed. So,
Mr. Bennett, did you have anything else you were going to add? I just see you're at the podium.
Yes, unless the objections have nothing to add, in which case I will sit down. But I'd like to know if they do.
oh, there shouldn't be anything to add. Everything was supposed to be added by May 1st, right?
Oh, I didn't know if they had any oral statement that they wanted to make. I see that they're both counsel here and they have one of their experts here. I'm more than happy to stand on what has been submitted, and I would ask that the record be closed and the matter be moved for a decision. But if you're going to allow some other sort of testimony or comment, then of course I would reserve my right to do it. That's
Sure,
all.
let's just ask. May I just ask the question?
Please, yes.
Is anyone else here asking to be heard tonight for the purposes of this matter? Otherwise, all written submissions were previously received by the board.
I don't wish to be heard, but I want to make sure that the board has our submission dated May 2nd. I'm sorry it came in a day late.
I saw it, yes. Oh, wait, maybe not.
I do not have a copy of the document from Ms. Margolin. I do just want to be clear, and I'm just looking to Mr. Wallach to confirm something.
Yes, we do.
Thank you.
Okay, was there, so that's been received by the board, was there a document that was rejected by the applicant's counsel because it was received late? If there was.
6 minutes late, not a day late.
Only because if the board received the second from Ms. Margolin, I would suggest that, I'm not
Oh.
faulting the department, then the
I know what you're
applicant's
talking about.
document should be received as well.
Okay, that email response where it was like, oh, it's closed, so we'll just put this aside. Then yes, it can be added to the file.
Okay, if that's okay, then I don't have any, if my 6 minute late document is okay to let in, then I have no objection to Ms. Margolin's day late document.
Right, I'm pretty sure.
Could you just please identify what, yours was May 1st?
It was 6 minutes, I believe, past the 4 o'clock deadline.
Okay,
Okay,
And
so I would
I
just.
thought I was back in Catholic school.
I would
Okay.
suggest that the record is clear. If there's been an acceptance in the May 2nd, I would suggest that the final filing by Mr. Bennett's office should also be provided to the board if that's not yet been done.
Yeah, since we have a copy in the file, we can make it available to the board.
If you'd be so kind.
okay, do we have to vote on that?
I would, just because it's been the policy of the board not to, I would ask if there could be a motion to accept applicant's latest exhibit as well into the record, given that we've also received Ms. Margolin's, which I think would be the fairest course.
Okay,
So is there a motion to accept all those 3 days?
so moved.
And is there a second?
Second. I'll second.
All in favor?
All in favor?
Aye.
And Mr. Wallach, if you'd be so kind just to share that with the board.
Sure.
With that, did anybody else have anything they were going to add? The record was closed. Mr. Bragman, what?
As long as we're talking about documents that came in late, I sent in a corrected version of the letter, had a typo in it. The date was listed as March 6th.
Testimony to be,
Right, so Mr. Bragman, you need to come up and identify yourself so that I understood.
It's a typo, right?
Right.
Okay. Yeah, I submitted,
Your name, sir, for the
I'm
record.
sorry, Jeff Bragman, I'm here for Eric Ruttenberg, the neighbor to the south. I submitted a letter on May 1st and had a typo in the heading. The date was inadvertently stated as March 6th instead of February 6th.
I submit that's a ministerial change.
Yep.
I suggest that the letter with the typo be accepted. It's otherwise substantively identical.
As to speaking, it was adjourned for all.
written submissions only,
Well,
so.
it said we're adjourning for all purposes. Are you closing it on the written submissions?
Did you,
I-
that was the board's discussion on the last date? Was there something that you were going to add that was new and different from what you had previously submitted?
I would say slightly, it was in my written document, but I haven't presented it orally to the board.
But if we have it in writing, the board will review it.
Yes, I suppose that is the case. One hopes, yes. I understood it was adjourned for all purposes today. I think that's what you said when you closed the record. You said written submissions May 1, we're adjourning it for all purposes on today's date.
My question to you though, sir, is, if you don't mind, if there's anything other than what is in that letter, I mean, the board has the letter, they'll review the letter. Was there something other than that that you intended to add? Because otherwise,
Well, I don't want to try the board's patience. I've been a lawyer long enough to understand.
That's a good idea.
That might not go so well, so reluctantly, I will decline to speak. I will agree not to speak.
thank you. So, just so that the record's clear, then we have Mr. Bragman's update, we've received Ms. Margolin's update from May 2nd, and as of this evening, the prior, which has not yet been shared with the board, will be shared with the board. And I have not had a chance to review that either from Mr. Bennett's
You
update.
sent it to Mr. Marlin, Ms. Marlin, excuse me, Mr. Bennett.
Thank you, sir.
When did you send it?
We sent it on the 1st.
So,
Okay, I think I saw that.
It's this,
You acknowledged
I'm
it.
pretty sure it's this one. I remember reading it when I sent that sort of flippant response, so.
but it was not made a formal part of the
Right.
record, so.
Okay, it's here, all three are here. Wonderful. So,
What does Porky Pig say? That's all, folks?
that's all, folks? Kind of. That is all, folks. You know, I kind of cut to the chase. The board needs, everything is closed now. We're not gonna vote tonight. We're gonna vote in 2 weeks because we need some time to deliberate on some conditions that we discussed. Nothing coming out of left field. And,
If I may, Mr. Chairman?
Yeah.
The thought that had been presented last time was that the board sensed that the public hearing will be closed this evening. I would suggest perhaps the matter be closed for decision and public deliberation at the next meeting of the board, because I'm sure those who are representatives would want to hear that, but that would allow the board to review any remaining documents, including Mr. Bennett's. And then at the next session, public deliberation would be held. And then if the board's prepared to vote, the board could vote, and it could be subject to a written decision for the board's review by council. But that's just a suggestion
no,
that I think would.
that's what I was trying to say.
Okay.
No, but, not as eloquently as you did. I just want to check with the board. 2 weeks is enough time, I feel. And if there's anything you want to tackle tonight, we could try that. But we really need time to sort of digest these 3 documents. And then,
I believe the board's next meeting
Oh.
is on about the agenda.
June 5?
June
so
5.
There's a little bit of extra time because of Memorial Day.
Yep.
Can I just add one thing? Nothing new, but it's always been my experience in appearing before this board for in excess of 35 years that you close the meeting and you vote on a proposed written decision. Because otherwise it creates issues as to what you're really voting on. So that's just a thought out there.
The reason that
I
I'm
mean, not
suggesting.
tonight, I didn't expect to vote tonight.
Understood.
Yeah.
Just to be clear, my suggestion to the board was that the matter be marked closed for tonight, held open for deliberation and decision on at the next meeting, which is what I believe the chairman was suggesting, assuming that the board is able to complete its deliberations, and then whatever happens will be subject to a written decision to then be prepared by council. That was my suggestion.
Yes. Do we have to vote on that?
No, I'm just
Okay.
asking, I would then ask if there's a motion to do that.
I need to hear from the rest of the board.
No, I'm just clarifying, so the vote would then not be on the 5th, the vote would be?
No, the vote could well be on the
Could be on
fifth,
the
subject to a
5th.
written decision prepared by council. There will be deliberation, vote if the board's done deliberating, then there could be a vote, and that would normally be subject to a written decision prepared by council consistent with the board's deliberations.
Does that sit well?
It seems fine. I'm just wondering about the vote without seeing the written decision, but subject to the
It would
written
be
decision,
subject
it
to
would
written
be
decisions. If the
vote
board's not
and then
comfortable with the
okay, then
decision,
we see
it
the
has to
written
be changed
decision,
to
okay.
fit with the board's deliberations.
And then adopted, the written decision would then be adopted
Absolutely,
at the
yes.
following meeting, or?
Yes.
That seems fine.
So is there a motion to that?
Motion.
Is there a second?
All in favor?
Aye.
Okay,
Thanks.
we've got some homework to do.
Thank you, Chairman.
Sure.
Oh, Mr. Bennett,
Yep.
this is correct. July 3rd is what you meant.
Yeah, I think that's what I meant. Okay. It's hard to remember.
Okay, thanks.
You all set?
Take your time.
So, normally I would ask to be excused, but do you want me to stay just through the end of the agenda in case there's a question that comes up? I can stay.
Okay, I mean, if they're all requests for adjournments,
Okay,
which we're just gonna buzz through, but I did wanna go over the language that Alex prepared for us tonight. I think we could maybe accomplish that, and
And then the board could also ask, if they had any questions for their work session about the application that was just closed, they could.
I'm sorry?
The board, if they had questions in the work session about
Sure.
the application.
okay.
Sure.
All right, so let's move over to work session portion. Does anybody want to ask any questions about 550, 554 before we move on?
The only point I would make is if people have, now that those who are present have left, if there's going to be discussion about legal issues as to that property, I can talk with anybody individually during the interim. I wouldn't want anyone who was present to say that the board then had their actual discussion after people left.
Ah, okay. Okay. That's something we shouldn't. Okay.
Sorry.
So moving on to item number 1 under work sessions, Hetty Creek LLC lot line modification. The applicant has requested an adjournment to the June 5th meeting. I'd like to move that we accept that adjournment request. Can I get a second?
Second. Just ordinary delays, or you give a reason, I mean.
No, there was a letter submitted.
From
that-
Linda. It's-
Yeah, I don't think it indicated a reason.
Nothing, okay, thank you.
I think she's wrangling neighbors, if anything.
Got it.
Yep, okay. So, all in favor?
Aye.
Okay. And then RRFAC F LLC, 550 Wickapog Road. Applicant has requested an adjournment to the June 5th meeting. I'd like to move that we accept that request. Can I get a second?
Second.
All in favor?
Aye.
Aye. And Woodhill LLC, 783 Hill Street. Again, the client has requested an adjournment to our June 5th meeting.
Yeah.
I'd like to move that we accept that request.
Just one quick correction, actually, the applicant requested July 3rd, but that ended up on the agenda incorrect if you look at the letter.
July 3rd for Woodhill?
For, for
Well-
783 Hill Street. So that should be July 3rd, not June 5th on the
Okay.
agenda.
Do July.
Oh.
Okay.
Which is a Monday, yeah. It's the Monday after the holiday.
It's the Monday in between.
Monday.
Yeah, that ought to be
Sorry, I just
interesting.
happened to notice the letter, so.
Okay, thank you. So let me revise that. I'd like to move that we accept the adjournment request to our July 3rd meeting for Wool Hill LLC, 783 Hill Street. Can I get a second?
Second.
All in favor?
Aye.
Alrighty, so that's passed. The April 20th minutes, has anybody had a chance to look at those?
Was there a site plan review that had an adjournment request?
Yeah, we received
Oh,
it
yeah.
by email, yes.
Yeah.
Okay, sorry about that. Site plan review for 865 Merrick Holdings LLC, also known as 22 Windmill Lane.
Windmill Lane.
Yep. They're asking for June 5th. I'd like to move that we accept their request for adjournment.
Second.
All in favor?
Aye.
Now we can move to minutes from April 20th. I have not looked at them yet.
I don't think I saw.
Okay. Let's push that to,
Has she sent it in? She didn't send it out yet, I don't think.
I haven't seen it.
okay. Is Antoinette on with us tonight? No,
Antoinette, where are you?
nobody's taking minutes.
Was she
Lucky
maybe
that
not
there's
let
not
in?
much.
Pardon me?
There's not much, at least.
Does the,
Charlie, is Antoinette lurking in your machine somewhere?
No.
They're not on, there's nobody in the Zoom room.
Okay.
Ooh,
Chairman, what I can do is that, I can get the transcript from the video, and if the board wants, I can just put together a list of the minutes for the meeting.
okay,
I can put
Thank
this
you.
together for you.
that would be great,
Oh.
thanks.
I accept.
Okay, so that leaves us with some policy resolutions. So, has everybody had a chance to look at this?
Yes. Yes.
Yeah.
And we know we're just basically trying to get this on the agenda as some rules of civility for our meetings, where it's in writing and we can refer to it, gives us
Yep.
some guidelines as far as how we can react to issues, and it also lets the applicants and their attorneys and the public know how things are going to be handled.
Should we read it into the record just so that people know what we're passing?
We probably should. Do you want to do it?
Well, it's good at it.
So I have a question.
Yes.
I think this is great, but should it be, and we need this, but should it be part of a published code of conduct that we should have? So that everyone that comes in here, not just the usual characters that are here, but everyone has something that they can reference to say, all right, this is what's expected of us, this is what I can say, this is what I can't say. And then, once they know what's acceptable behavior or not, if they don't abide by that, now you have,
Well, the
A way to deal
idea
with
is
it.
that this language will go on to the agendas.
but should it be more than just behave yourself or else? Right? You know, this is what we expect in a package, and here's how you're supposed to behave, and here's what you can say, and
So at the time of application?
exactly. So I think this is great for someone that's very familiar with the process and what is protocol for an appearance at a public hearing in front of the planning board, but I think that some people aren't as familiar with that or aren't here as often, and maybe that might be helpful.
I mean, yeah, that's kind of a good idea, that's a good idea, and maybe for every board. I don't know how they would feel about that, but,
I think it's a good idea for the boards to be able to conduct business, you know, hearing everybody and not being subject to any kind of intimidation or uncivil behavior or, you know, even threats. But it should be published.
So-
And I think for all boards, not just for our board.
I agree. But what's the mechanism for this? Do the trustees have to? Because we're basically changing some policy for some application submission, right? Like, I think that this should be, whatever this document becomes, should be signed by the applicant when they,
Right, so this board can enact a resolution and policy for this board. If this board wants other boards to consider enacting it, my suggestion would be to share it with the other land use boards and with the Board of Trustees, and you can say this is a policy that the planning board is adopting for its cases. We hope it will prove useful. We're referring it to you for your own consideration and potential use.
But what if we want to take it a step further and just,
Then it could be referred to the Board of Trustees for the Board of Trustees consideration as to whether or not the Board of Trustees wants to set this up as either a village-wide land use policy that all of the boards shall, or put something in the code that says, I would just suggest that they could pass a local law that says, for every application moved before land use boards in the village, the following protocol shall be followed. That is something that could be considered as the local law.
If we do it just for this board, is that a resolution of the board? Is that a law?
It's a resolution.
It's a resolution.
This board can't,
So it's written
Great.
in legalese.
yes.
Like
it is.
Yeah.
This is the resolution, ready for a vote.
So if this was approved, the board could also, as a part of its resolution, say, we're moving to approve, and we're also going to ask the building department with every application that comes before the building department, make this part of the packet that the applicant has to receive. So they would receive the usual information plus the resolution that says, here is the protocol that we expect you to follow when you appeal before the board.
Right, so
We can
I'm,
also make it a part of the website where we have requirements for applications. For example, like the ARB has a policy specific to driveway gates. We make that policy available to applicants, so they're aware of it.
I mean, I like where Mark is going with this. I think I would love to see it just voted as village law. And then that applicants have to read it and sign off on it with every application, regardless of what board it's for. Because I think one of the problems, honestly, on record is that from the top down, I don't feel like we're supported in these issues. Everybody's just sort of tolerated poor behavior for years. And we're kind of stepping up to the plate and saying we're not going to tolerate it.
I can certainly send this to Andrew Preston, who's the village attorney, and say that, I think he's aware, but I could say the planning board is considering adopting this as it would relate to the planning board, but they would respectfully ask the Board of Trustees consider making this a village-wide requirement for all of its land use boards. Would you consider that?
I think I would suggest also that in terms of due process considerations and having this hold up, to any First Amendment challenge, or just because you have to consider it in that context, that there might be, a warning from the chair, it says, or anyone on the board, but then a letter to the person violating the procedures of the board as to specify what it is that was objectionable, so that they could then have a due process ability to answer that. There should be some, modicum of procedure in there so that it stands up to a First Amendment scrutiny, because that would be, a potential objection to something like this, which I think is really very much needed. We need this, but, that's the.
So you're talking freedom of speech?
Yeah, that due process to applicants, you have to be able to zealously, defend represent your client from, if you're a lawyer, or an applicant has a right to speak, forcefully about their cause, but, we're not talking about that. We're talking about bullying, abusive language, threats, things of that nature that shouldn't have any place, because it affects, it's a chilling effect on the work of the board or anyone's desire to serve on the boards. So, I think when this has been done in other contexts, there might be a letter that follows, if you decided, for example, to adjourn a meeting because you can't take testimony and,
Right. Okay.
So if Tony decides to adjourn a meeting, are you saying that is not due process?
No, Tony would have, make a finding and tell the person, you've got to keep your voice down or stop shouting or whatever was going on.
Or allow people to speak.
He would be making a finding at the time,
Got
and
it.
he would be stating that. But then, I guess for clarity, there might be a letter following that,
Understood.
as a warning, so that then, if somebody repeatedly violates that,
Then
then,
what?
the
Then what?
board can you know, take it somewhere, I don't know.
Well, so where do you go next step? If someone just ignores it, what can we do?
Then I will turn to him and say, Chairman, I think you should terminate this for now, and we document it.
Right, and we just keep
We
refusing
could
to
have a
hear the
vote.
application.
We can have a vote.
You can do that.
Sure.
Of
yeah.
course.
And just document.
We don't even need this to do that.
Send a letter out. We could do it now, but this makes it official.
So look, you raise a really good point, but waiting for the trustees to make this a law may not happen in our lifetimes, right? And we need something now.
Okay.
So, and I don't want to hold this up, but I'd like to see more than this, right? We can adopt this because I think it's great and it's needed just in my short time here. It's like, wow, this is really needed.
Mhm.
But I'm looking for sort of a rules of the road or a code of conduct, and I think, you know, we can be the pointy end of the spear on that. And if the rest of if the other boards want to follow that because they see it working here, then, you know, that's great. They can copy.
Tony, how often do you meet with has that ever happened yet? You meet with the other chairman?
Monthly.
You are doing it monthly?
Yes, and I missed the last one, unfortunately.
Do the next one. Tell them this is what we've done. Take
I
it
will.
up.
I will, definitely.
And if they want to improve it, call Wella.
Okay.
But the question is, how do we draft sort of a code of conduct, or I wouldn't even know where to start, or rules of the road?
Just put that in. That's really nice.
Well, this is more if you're misbehaving, this is
Yeah.
what happens, but
Well, every-
there's no, I mean, do people really know how they're supposed to behave in this?
Some do, some don't.
But, so that's my point, maybe is it possible to, I mean, Alex, what's your suggestion?
And early
Somebody
in
would
this
have to
application.
propose something.
What was that?
Somebody would have to propose something if there's a rules of conduct for appearing at a
Yeah,
public board.
For rules to appear,
Right,
that's right.
and each board is free to adopt their own policies
It's up to the
suitable to
judge.
their own needs, or, as was mentioned, the trustees could adopt a village-wide policy or law.
So a couple of things to bear in mind. So this would be a policy that covers the general public, but don't forget that any lawyer who appears before you, or a professional who appears before you, they're going to be also bound by their separate professional rules of conduct. So if they are violating those rules of conduct, complaints can be made to their various disciplinary committees, which is separate from this.
In addition to it.
In addition to this, I don't disagree with Mr. London that this is sort of a floor, not a ceiling. So if this board were to approve this tonight, you can then tweak it as time goes by. In terms of an overall code of conduct that people would need to follow, the Board of Trustees already has the ethics code, but that doesn't apply to people who aren't officers of the village. So it's a bigger project that I think would take more discussion, and it would take quite a bit of time to consider and compare what other villages may have done. So the thought would be, if there have been problems already here, to the extent this would be helpful, you could put it in place now if you want, and then change it as time goes by. And we can share this with the village attorney to talk to the Board of Trustees about approving it. And I do think, I myself showed up late at the last chairs meeting, but I do think that this was actually discussed at that meeting.
It was?
Yes.
Okay,
I do think it was, because I think it was circulated after that.
okay, great. Well, Alice attends those meetings too, so she may have,
Right.
Well, yeah, I guess one of the questions is the ethics board is supposed to ensure that all the boards in the village can function efficiently and
But they only
can
follow
make
complaints.
fair decisions, and you know, as you say, they can only discipline somebody who works for the village, but you know, they have to ensure in some way that the people on the planning boards can serve in an environment that, you know, makes it possible to serve on the boards and hear testimony and decide cases, you know. So, you know, I think that's sort of an open question, is then what is the obligation of the village to ensure that can happen? There's been a lot of discussion about open meeting laws, you know, which is one thing, but this is another thing where you can't really have you know, you can have an open meeting, but you can't have a fully deliberative meeting if people are subject to intimidation or bullying and things like that. Which is unfortunately seems like it's part of our times, but I think we should do whatever we can, as Mark was saying, to try to, you know, not have it that way.
Right, and I think the purpose of this type of provision is to say that this board does not intend to in any way shut down anybody from making a reasoned argument about any application they're making. You can present all the facts, you can make all the arguments you want. But at the point that you make it personal, at the point that it goes beyond that and becomes something that's vindictive or assaultive or threatening, something that has nothing to do with the issue before the board can and will close that down. We're not going to prevent you from saying anything that you need to say. It's similar to what would happen in court. It's not a violation of somebody's rights for a judge to say, you're not on point here, we're going to bring you back to the point. You're being belligerent. If you're going to continue with that, you're going to step out, and we're going to continue this on another day. And if that's then made a part of the minutes, which anybody can pick up, I don't think that would lay the groundwork for a First Amendment claim.
No.
The board never said to anybody, you can't make your argument. Make your argument. Make it for as long as you want, for as much as you feel you need to do so, but don't go beyond that into the realm of impertinence or being inappropriate and off point. So
And the board can't limit the length of an argument.
I
mean,
think
if
that
some-
the board can.
can.
I think that the board can. I'll give you an example. In administrative proceedings, they will often say, we will stop you if what you're saying is repetitive. We will stop you if what you're saying is not relevant. Because there's only so much time in a day. So if we feel that you're off point, we're going to reel you in.
Procedure.
We've already heard it.
I think this board has put time limits on public comments before. The trustees regularly do. They limit public comments to 3 minutes and enforce that strictly.
You know, it's a little tougher when there's a public hearing about a particular issue to say we're going to hold you to 3 minutes, because then I think you run into a problem of if an applicant has 4 experts to speak, it's hard to say everybody can speak for only 3 minutes. But I do think that boards can say to people, look, we'd ask you to make your verbal presentation a little briefer, and if you have something that's really going to take 30 minutes to say, maybe you should put it in writing, because we're going to need to read it.
Yep.
And then some things seem like filibustering more than it does
Absolutely.
argument, but not allowing someone to ask a question or constantly interrupting or things of that nature where you can't
Right.
hear the facts, or take testimony.
For the second time, 5:50, 5:54, when I was trying to catch up to the speeding train, I went and got out of the personal files of the late Charlie Weller, who was the predecessor to our gentleman back there. I believe at one of the hearings where this applicant's late wife was making yet again another repetitive thing about how severely this property went down when it went south. It reduced a neighbor to tears. For the public record, there were tears on the record. So it's wide open. Anything can happen to us. We just need to have the power, which I think this does, to restrain it.
Right,
So you don't like the other guy, you can always cry.
right. And I just think that
It's open.
board chairs need to, when I started, I didn't feel empowered. You get caught off guard when instances like that happen. So being a board chair and understanding that you've got this document behind you and the support of staff, it's important to run a civil meeting.
So, my question would be, in terms of this resolution, if the board was considering approving it tonight, what could happen is if the board approves it tonight, it could be made a part of the minutes for this meeting. It could be filed with the building department, and I can certainly circulate it to the other land use boards for their consideration, and follow up with Mr. Preston, who's village council, to see if they want to take it a bit further.
That's a good idea.
I'll make a motion to that effect. I think it's a good motion, Chairman. May I propose that we follow council's recommendation to approve this now and start the process? That's my motion.
I just want to read this last paragraph. Adjourning the matter of future dates. Okay. I just want to make sure that all 5 of us agree with the language before we move.
I read it 3 times. It's changed nicely.
Okay.
It's been improved.
I agree with the language as is,
Yeah.
you know, as long as we can add to it or revise it as needed. If
course
we
we
can put
can.
it on the agenda again, if we wanna do that, that we're being advised that we can add to it, if it needs to be tweaked, or if we feel like we have to delineate what, you know, types of situations, you know, we're talking about, we list a few of them, but if there, you know, we feel there needs to be more discussion about that, we can do that at a later date.
All right, then
And
I
I think we could do that.
Let's do it then. It's a
Second.
good start.
Yeah, I'll second. I want
Do we need to restate it?
No, I think, Mr. McFarland
I moved.
was adopting the motion. Just, my understanding was that the motion that he was adopting was that the document as prepared would be adopted for this evening's purposes and made a part of the minutes.
Okay.
The board understands that it
Yep.
can be changed over time by further resolution, and then I will share it with other land use board chairs and with council to the village for their further consideration as well. So,
Okay.
And is there any point in reading it into the record for,
I don't know that the board has to, we certainly could if you wish, but it's going to be made a part of the minutes, and it will also be, maybe we should add that to the motion, is that it could then be posted to the village's website, and made a part of the application process for any person who comes before this board.
Okay.
okay.
You okay with that?
Mhm.
All right, so somebody needs to call the vote on this. Can I do that?
Well, there was a motion, and I believe Ms. Bernstein was seconding,
Yep.
and I can poll the board if you wish.
Yep. That'd be great.
Ms. Cowell?
Aye.
Mr. London?
Aye.
Ms. Bernstein?
Aye.
Mr. McFarland?
Aye.
Chairman Piazza?
Aye,
Motion carries.
great. And I have a wet signed copy for you.
Oh, excellent.
Okay.
And is there then a motion to close unless the
Before
meeting?
we do, I just wanted to make sure the board notes, because it's on the last page, the next meeting is gonna be on June 5th.
Yes.
Because of the Juneteenth holiday, there is no meeting on the 19th, Village Hall will be closed, so the following meeting will be July 3rd, where we are open the day before Independence Day. So just wanted to make sure we'll have a quorum on July 3rd.
Okay.
Yes.
Yep.
Okay,
Yes.
great, so those are our next two meetings.
Yep. I think I want to just let the board know that because of my professional life, I'm going to have to step away from the board. And I've discussed it with some of you, and I just wanted to discuss it publicly, that it has really nothing other to do than the fact that I don't feel that I have the time to do the job properly. And it's not how I like to operate. So I'm committed to staying on the board until we resolve 550, 554 Hill Street. And I think it's kind of perfect timing because all the other applications are new. And the mayor and trustee Manger know about this. Supposedly they're looking for another one. But I'm going to miss this and all of you. But duty calls me in another direction. And I'm hoping that there's a day when I can come back to doing this in the village because, like I said, I really do enjoy the people that I'm working with and trying to make a difference in the village. So,
Now we are
Thank
gonna
you.
cry.
no, don't cry.
Well, thank you
We'll
for
miss
being
you,
here
Tony.
for the time you have spent.
My pleasure.
Yeah, thank you, Tony. It's
Yeah.
been
Whatever you do, go out in style.
fantastic.
Of course.
And then I would I'm sorry, was there then a motion to close the formal meeting?
Yeah.
Yes.
That was
Is
the
there a second?
preamble to the motion.
Second.
Second.
Meeting
All in
was
favor?
closed.
Aye.
Aye. Okay.
I didn't mean to interrupt that, and you will
No,
certainly
that's
be
fine.
missed.
I wanted to get it out there that it's not.
Thanks, Tony, that was very